Good morning, everyone. Thanks for joining us. This webinar, brought to you by the European branch of the Chartered Institute of Arbitrators, is about preparing witness statements, including interviewing the witnesses. So it's going to be on witnesses of perception chiefly, but as we'll see shortly, there's going to be a little extension on that, an intermediate category between perception witnesses and expert witnesses. So you as arbitration practitioners know how important it is to prepare the witness statements. If you think of arbitration in evidence schematically, it's more or less documentary evidence and witness evidence. There are some further elements, of course, but they're of less importance. And documentary evidence is sort of inert, isn't it? There's not a lot you can do to finesse it as an advocate. But witness evidence is very different. I'm not saying it's a blank slate, but you can do an awful lot to advance your case through the savvy preparation of witness statements, and also in how you interview witnesses. One of the big issues is, of course, the degree to which counsel can intervene vis-a-vis witnesses. Surely you wouldn't want to influence the substantive testimony, but Americans say that it's mispractice not to meet with your witness and prepare the witness for examination. Today, we've assembled a very distinguished group of practitioners, expert on this topic. I'll present them in order of, alphabetical order by last name. That means we're going to first present Professor Dr. Johannes Lambrecht, who is an arbitration practitioner of some standing here in Geneva, Switzerland. Sorry, not all in Geneva, Switzerland. And he's a member of the Bar of Germany, Switzerland, and England and Wales. He practices with the Geneva office of the Swiss law firm Walder Wyss, and has many years of practice. He also is an academic. And he lectures at the University of Fribourg, and various other universities. He is the co-editor of the ASA Bulletin, the Swiss arbitration publication. Dr. Harris P. Medanis is a fellow of the Chartered Institute. He is a member of the Athens Bar, and he's a certified mediator, member of ICC Greece and the Institute of World Business Law of the ICC. He has degrees both from Greek universities and English universities, and has a PhD in private international law from the Department of International and European Studies of Pantheon University of Athens. He has immense experience in these matters we'll be speaking about today, and many others in relation to arbitration and private international law. Jose Paez is a member of the Chartered Institute of Arbitrators. He's a founding member of the Madrid boutique law firm PZCR, which specializes in EU and competition law, sports and entertainment law, tax law, commercial arbitration, and international contracts, all of which I find very interesting, except tax law. I recognize its importance, but I think you have to be a very studious person to want to specialize in tax law. So Jose practices in competition law, sports and entertainment law, telecommunications law, and arbitration in international contracts, and not tax law. He's a Spanish lawyer and also a solicitor in the Bar of England and Wales, a solicitor of England and Wales, and he is admitted to the Register of French Advocates. He speaks Spanish, English, French, and Italian, and has working knowledge of German and Portuguese. Baptiste Rigaudot is an arbitration practitioner in his own law firm called Lead Up Advocates, based in Paris, France. Baptiste has extensive experience as a lawyer in international arbitration in Geneva and Paris and perhaps elsewhere, doing cases in commercial arbitration and foreign investment arbitration. Baptiste is a member of the Paris and Geneva bars as an EU lawyer, and works in both civilian and common law systems. So those are our participants today who are going to be guiding you on this topic. I don't want to take much more time in this introduction, but I will lay out the format. It is as follows. Each of the speakers will present one of our subtopics, and then the other speakers will have an opportunity to fill in material and comment. There'll be some discussion at that level, and then we will answer any questions which you will please post on the chat. Okay, so you can't actually speak them. It's just in terms of efficiency and the limited time we have, it'd be much easier if you just post them on the chat and we'll address them. Ideally, orally, and if not, if time doesn't permit, we'll do it in writing over the chat. Okay, so we do encourage you to ask questions and be actively involved. This is recording. I want you to know that this recording will be placed on the website of the European branch of the Chartered Institute of Arbitrators as an installment in our series of fundamental skills and counsel practice of international arbitration. So that's all from me. Let's begin now with Jose discussing the role of witness evidence and witness statements. Jose, please.
Thank you, Philip. Good morning, good afternoon, or good evening, depending where from you're connecting to this webinar. First, I want to thank the European branch of CEARB for inviting me to participate in this webinar. I've been asked to treat a number of topics which I believe are relevant to get us all started in this webinar. First, I'm going to try and answer a very, very basic question, probably to you all, which is why witness evidence? The simple answer would be to say this, basically the most readily available way of finding out about something is asking, right? So that explains that since time immemorial, witness evidence has been resorted to prove or disprove facts in issue in a dispute resolution context. So that has earned witness evidence the central role that it has in the determination of legal disputes in all major legal systems. This is so in spite of the acknowledged difficulties with presenting and assessing witness evidence that is far from unproblematic. You will concur with me that human recollection can become hazy or even completely wrong, especially over longer periods of time, and that human recollection is as well impacted by unconscious bias or by wishing to help the party in whose case the witness is providing evidence. Also, the fact that in modern disputes, much of the evidence will be documentary. Well, all that has not called into question the relevance of witness evidence that need to be resorted to. For instance, despite of the importance, and we will see that afterwards, of documentary evidence, it could well be that the document does not convey the whole story, or that simply there is no document addressing a particular issue, or just a part of the case you will come across this revolves around a conversation which was not the subject of a documentary record, or even an issue in dispute is a person's state of mind or understanding of certain subject matter. So the conclusion on this first part of my presentation is that it is very, very rare for an arbitration to be on the documents only. And this statement is true not only for common law inspired arbitrations. That gives you an idea of the importance of witness evidence. So the concern of us arbitration practitioners should be not so much the relevance of witness evidence or when to introduce it, but how to maximize its reliability and the position of assessing it. Let me now talk about how witness evidence is treated in international arbitration, and especially vis-a-vis contemporaneous documents. There are, in general, two approaches to witness evidence. The common law jurisdiction approach, Philippe touched on that at the beginning, what the approach is adversarial. So the focus is on the testimony of the witness that will then be subject to probing and challenged through cross-examination. Instead, in civil law jurisdictions, the approach is more inquisitorial, and we will find limited questioning normally by the decision maker. So the role of the parties' counsel, or in the opposing parties' counsel, is not that relevant when it comes to questioning. But we're lucky that in international arbitration, the ever-broadening diversity of practitioners has enabled the reconciliation of these two approaches. This has been done through soft law, like the IBA rules on taking of evidence in international arbitration. However, it must be admitted that common practice in international arbitration reflects predominantly the common law approach. But it's been precisely that approach that has been subject to criticism in recent years, because it's said to be failing to provide the best evidence at proportionate cost. At the same time, there continues to be some reluctance when it comes to witness evidence, and that is in particular on the part of civilian practitioners, because they argue. I come from a civilian jurisdiction, and I tend to share that approach. So it's argued that contemporaneous documentary provides much better evidence than witness evidence. So then we can argue the witness evidence is a cardinal type of evidence in arbitration that competes in a way only with documentary evidence in order of importance. And quickly, how does witness evidence fare against documentary evidence? Against witness evidence, we can say that it presents remarkable complexities that affect its probative value, because witness evidence is more variable. For instance, as a function of the characteristics of the person, of the perception of the evidence, and of what befalls that person after having apprehended the evidence. And this is further, the breadth of variation of witness evidence is expanded further by factors that are external to the witness or to the witness's testimony. And those are, for instance, how counsel presents the witness evidence, or how it is examined or assessed by the arbitrator. In favor of documentary evidence, you will agree with me that we live in a time where it's because of the prevalence of emails, text messages, social media, most agreements and discussion of some legal significance will have an electronic footprint. So that's why it is argued that factual findings should be guided by contemporaneous documents, and when necessary, inferences can be drawn from those documents or from known or probable facts. Why witness statements? Are there any alternative to those? Well, you know that the intervention of witnesses in international arbitration is done through the submission of written witness statements, which basically contain the evidence that the witness would otherwise give orally, the evidence in chief. So these witness statements should be, of course, the evidence of the witness, and if practicable, it should be in the intended witness's own words. and in their own language. So it's much better to draft the originally record the testimony to be reflected in the witness statement in their own language, and then eventually translate it into the language of the arbitration. So witness statements, what are the benefits of witness statements for arbitration? But they reduce the length of a hearing by avoiding obviously the oral examination in chief that can take quite some time, because as you know, it's led by open-ended questions. It will assist the tribunal in preparing the award, because it sets out the evidence in chief in a coherent narrative. It gives the parties a very advance notice of the evidence which the other party's side intends to rely on, and the actors from the parties a means, this is quite important in my view, by which they can set out their view of the story. It's been said that it can even encourage settlement of the dispute before the hearing, because the parties will understand better the elements of the other party, and of course allow witness statements allow for more focused cross-examination. Just to but what are the weaknesses of witness statements? Well, the main weakness is that witness statements are not serving basically their purpose. They present quite a number of deficiencies that are attributed to the fault of lawyers, such as over lawyering. So they have become the proud of lawyers drafting this too much commentary and quotation from documents, and they are unduly used to make legal submissions. And so the overall result is that the arbitral tribunal will tend to place less weight on the witness statements, because they think that they have stopped contributing to the resolution of the dispute. I will stop here, Philip. If we have time afterwards, I will address the alternatives, which I believe is also quite an interesting topic. Thank you.
Okay, Jose. Yeah, thank you very much. Any comments on what Jose has presented? Harris?
Yeah, thanks so much, Philip. I think Jose, set the ground in a very elaborate way. So we know where we stand right now. My only small addition would be about the obligation of the lawyers to let the witness know that they should avoid any false statements. This is also in the IBA guidelines on party representation. This is mentioned there. Of course, this is something that I understand will be dealt in more detail later on in this seminar. I mean, the cooperation in a way between the lawyer and the witness, but I think it's very important to stress it also at the outset, because actually the witness statements are there to help us, to the tribunal to understand what's happening.
Yeah, okay. I have a comment. I was just wondering, in the common law tradition, there weren't any witness statements. That sort of was introduced in about 1989 with the modernization of the civil procedure rules. So what happened before, as you know, if you're from the common law world, in particular the United States, is you had the witnesses just presenting their evidence at the hearing. I'm not going to say led by counsel, but under the control of counsel. The counsel would ask questions, and there were all sorts of rules about that. You're not allowed to suggest answers, use so-called leading questions with your own witnesses. And the witness would tell their story right there in front of the judge. And so why is it that in international arbitration we have witness statements now? Almost invariably, you never ever see this other system, even though the common law tends to dictate, is that too strong a word, how arbitration procedure operates? Why don't we ever see this sort of questioning with direct examination or examination in chief? Why do we have witness statements rather? Anybody want to venture a comment on that? Harris?
Yeah, my initial reaction would be to say that something that Jose also mentioned, I believe, that there's a need to avoid surprises. so people know in advance more or less what will follow at the actual oral hearing. Of course, this doesn't mean that the oral hearing will be limited to what will be mentioned in the witness statement, but we have a very good idea of what's happening.
Yeah,
Actually.
that's definitely operating. I mean, effectively, the modernization of the CPR attempted to front load the evidence submissions, the submission of evidence to avoid surprises, indeed. Having witness statements is also a way of being more orderly. You know, you get a nice statement all together, one-stop shopping. You get everything from the witness, and it's, you know, put in a sensible order. And it's more efficient. So there's that advantage. But I think it's also true that there are some disadvantages. I could suggest some. I don't know if you want to. One of them is, of course, this risk that behind closed doors, counsel is working on the witness and effectively dictating or determining, influencing what the witness says. When the witness provided their direct evidence in front of the judge, it was, you know, much more difficult to disguise the role of counsel. And this is something that I think we should never lose track of. We're always going to be concerned about the role of counsel in the preparation of witness statements. Anyhow, as you probably know, our speakers do, opposing counsel can always probe at the degree to which the witness statement isn't an authentic statement of the witness's views. You can get at that effectively in the hearing. So that is, if you like, a counterweight. Any other comments on Jose's presentation at this stage?
Yes, I was going to just answer your question in also, Philip. One aspect is obviously cost. It's much more efficient in terms of cost when you've got a statement before than just having a witness take 1 or 2 days to give their evidence for the first time orally. And the second one, obviously we all agree that it improves the efficiency of the tribunal preparation as well, to know what's coming and to know where they're interested in the evidence of the witness, if they've got the witness statement. I mean, certainly as arbitrates, that's helpful to know, to have that in front of me to know what they're going to say and what are my questions and which documents, if they are not put by the other side, I can put to them to see to ascertain some points of the factual context. So that improves preparation. And in the end, as we all agree, I would think preparation of the tribunal is beneficial to everybody for the swifter resolution of the dispute.
Yeah, absolutely. Okay. Jose, did you say you wanted to make some more comments at this stage, or do we move on to the questions if there are any questions? I think I've told everybody that questions should be put over the chat, but in fact they should be posed over the Q&A. And as I see, I don't think there are any questions currently. No, there aren't. But Jose, did you want to comment further, or do we move on to the next subject?
Well, I have taken up quite some time, so I can save those for later in case there is time. So maybe we can take some time later to look at the alternatives to witness statements.
Okay, yeah, and so all questions, please, over the Q&A. You're most welcome to ask questions and participate actively. Now, in the absence of questions, I'll just check again. No, it's like Christmas time, you know, when you're a child, you get up early and look under the tree. No questions. Oh, wait, I have some. Okay, anyhow, we'll see how we get on. Right, okay. We'll go on to our second topic, and this one is going to be Harris. Harris, drafting witness statements and procedural rules. Please, could you let us have your thoughts?
Sure. Thank you so much for this invitation and for being able to be part of this discussion, the debate. Well, in my part, there will be actually 2 subtopics. One will be a reference to some usual rules one has when drafting, has to follow when drafting witness statements. And a second subtopic will be about the IBA rules on taking of evidence, which seem to be the more elaborate text we have in relation to this subtopic. So as a starting point on these procedural rules, we know that in arbitration, party autonomy plays a huge role. And in that sense, prima facie, people are allowed, can do whatever they want when it comes to drafting. Of course, this doesn't help, so having some guidelines is important. In that sense, we have various rules of institutions that say something more. For example, the LCIA rules in Article 20, they're more precise on that. They require written form for submission for the witnesses, therefore written statement. And then there is reference to the fact that there can be, or there shall be an oral examination of these witnesses that will submit a witness statement. Apart from that, for example, in the UNCITRAL rules, also have a reference on that, but again, not saying anything more than the statements must be in writing and signed by the witnesses. As I said before, the more elaborate references, the one of the IBA rules, I'll come back to these after I present some general guidelines that have been created on the basis of the practice during the years. So, as we have already said, tradition plays a huge role. We have this civil common law dichotomy. We all know that these, in relation to witness statements and witnesses in general, is important. For example, cross-examination in common law countries is preponderant. In civil law countries, it is something we do not really know much. On the other hand, or perhaps at the same time, we have also the fact that in civil law tradition, the role of the judge and of the tribunal, if we're in a civil law environment, is in a way the tribunal or the court dictates more how things will happen in relation to the common law tradition. So this, in a way, can be reflected also when it comes to witness statements. But as we know in arbitration, there is an effort to have a kind of in a comparative approach, find some common solution. So this is what I'm going to say now. So essentially, the idea is that each statement must have certain characteristics like the full name and address of the witness, a description of the facts. It's important to stay to the facts, not add any legal reasoning or rationale of what's happening in the specific case. And of course, it should be finishing by a statement of truth. So what do we mean by statement of truth? That's, again, as we said, culture plays a role. There are countries where one can even not that much anymore, and much depends, of course, on whether there is also a guideline of the specific tribunal, what they expect to see to have on this. But essentially, there must be a confirmation by the witness that what this person says is the representation of the truth. And of course, the reference must be to the, as we say, direct evidence, which means the actual personal knowledge of the witness. This does not mean that indirect evidence can never be given. I mean, one can include perhaps something, but it's not as strong. I mean, what one expects to hear from a witness is what this person really knows. Here, of course, we have a little issue which relates to the fact that, especially in arbitration, most of the times people that testify as witnesses, they have a link with a case. So in my tradition, the civil law tradition, this is an issue. I mean, a Greek court or in most civil law courts would be reluctant to apply to use the testimony of a person who has an interest in the case. Of course, in arbitration, this is not the case. So this is another interesting cultural issue. And of course, when it comes to the relationship with the supplementary witness statements, yes, there can be additional witness statements at the later stage, depending on how the case goes, in a way of an answer to previous witness statement on the other side. Now, going back to my last point, which is the IBA rules on taking of evidence, as I said before, this is the more elaborate text we have when it comes to what we can include in a witness statement, or what the form should be, what the form of witness statement should be. So, full name and address of the witness, and a statement regarding the relationship of that person with the parties, and of course the interest in the case. A full and detailed description of the facts, and the source of the witness information in relation to these facts, the reference to direct evidence that I made before. Of course, a statement as to the language, because the language is always important. One needs to file the statement in the language of the proceedings. But if the person who testifies does not know the language, there should be a translation, there should be an attestation of the correctness of the translation, which is also important. And of course, this should be followed by an affirmation of the truth of the witness statements, something that are already discussed as a general obligation of the drafters, and a signature of the witness, the date and the place where the witness statement was drafted. So more or less, this is what I wanted to talk about at this point. So.
Thanks, Harris. Comments from the speakers?
Yeah, I wanted to follow up on the point that the witness is interested in the testimony. I think that comes partly with the territory, because in arbitration you're always dealing with a contractual relationship, or almost always. So people are involved. So I think the closest we get to an uninterested witness is someone that left the company, ideally on good terms. That can sometimes be a very strong witness if that person still shows up. And then the tribunal has someone that is no longer in the game in the company. But other than that, I think we have to always deal with witnesses that are interested in one way or another. The difficulty is more to assess how they are interested, because sort of the boss of the department may be less interested than the engineer on site, or vice versa. So it's difficult to find that out. And one other comment that makes it also difficult for counsel when we interview the witnesses, because we often have to, or we try to get to the bottom of things, but then these witnesses are already interested when they talk to us. So that's before anything goes to the tribunal. So that's something we have to keep in mind ourselves. Who is interested in what within the team that we are talking to? And depending on this, we need to sometimes approach witness questioning very differently.
Yeah, absolutely. Yeah, is it right that there's a rule that the witness has to put everything he or she knows in the witness statement? Is that a rule? I don't think it is. Well, there are two things, isn't there? I mean, they don't have to put the stuff that's going to hurt the case of the party that calls them. There's no such rule. But more interestingly, one of the points of witness statements is to make things efficient. So it's probably right that there's at least an expectation that the witness is going to put everything, that they want to say in the witness statement. But as Harris points out, there are supplementary witness statements. Usually you want to keep your material of the supplementary witness statements to stuff that arose in subsequent statements of case and subsequent evidence. In terms of efficiency, it also looks a bit funny if the witness keeps adding stuff, because then, counsel of the other side is going to say, well, if that's actually true, why didn't they say that at the beginning, It's like they're changing their story. Supplementing your story is a bit like changing your story, in my opinion. I try to avoid that as counsel.
And if I may add something on what you said, I mean, if someone doesn't say something as a witness who is not in favor of the party that this person is testifying for at all, as if it never happened, this can be an issue. So at least some recollection of a fact that this person is aware of may make sense, even if, you know, it's not 100% precise in a way, you know what I mean? So you don't, in that sense, I think it will help the process and perhaps the party that this person is testified for.
Yeah.
Philip, if I may,
Yes.
even if there is no written rule about what should be included in a witness statement, it is true, in my view, that to the extent that a party is calling a witness, that party has to encourage the witness to basically include in his or her testimony every knowledge relating to the events that are relevant to the issues in dispute, or basically to the subject, to the issues that are the subject of the dispute. Rather, there is no, in my view, nothing good will come out of just not mentioning something that you believe already at that stage that is relevant to basically to inform the tribunal, to set the scene for the tribunal. I'm not talking about supporting the case of a party necessarily, but whatever is added afterwards, unless it is in reaction to a counter witness statement, will have to come with some explanation that may call into question the original testimony of the witness. So I would advise against not being comprehensive in the let's say first witness statement or main one.
Yeah, I totally agree. Further comments? How about this? It's certainly not a rule, but is it actually good practice? As Harris says, that you want your witnesses of perception actually to have seen or heard or smelled or whatever, you know, sensed the material they're testifying to. Is it good practice? It's certainly not a rule to get the witness to identify stuff they know because they saw it and heard it, and stuff they only believe to be true, because there's some, if you like, remoteness between them and the actual occurrence. Is that good practice? Do you actually use that in your witness statements when you're assisting witnesses? I do. I
Right.
mean, I tend to.
Sorry, I was going to say this is something will be discussed later on in the webinar, but
Well, sorry.
answering your question, I find it very risky to for the witness and for your own case to say that to include stuff that they don't have direct knowledge of and which can be supported pretty quickly with the document. Obviously, tribunals are not very keen on being hearsay spoken to them or referred to them. So that puts, I mean, in my view, the witness is being put in a dangerous position, and they say in their witness statement that they believe something happened and that they're not entirely sure it did happen. So I don't see the point of having them risk their credibility pretty easily if the other side has a document which contradicts their belief. Focus, I would advise focusing on what they actually know, what is direct knowledge. I mean, of course, sometimes as arbitrator, you also are interested in the feel of negotiations, for example, or of what the witness felt when somebody entered the room, or etc. But that's, I think, pretty minor part of a witness statement. The most important part is supporting is evidence being supported either by a document which has been authored by the witness or uncontroversial facts.
Yeah, Okay, thanks, Baptiste. If there are no further comments at this stage, let's look at some of the questions and answer them, or attempt to answer them. Anonymous attendee asks, what are the differences in drafting a witness statement in litigation, for example, in England, and in arbitration? I could say stuff on that, but does anybody want to speak first? In England, you have very specific rules set down about what witness statements are meant to do and how they do it. So in particular, there's a very firm rule that a witness statement has to be the witness's evidence, yeah? And it has to be, get this, in the witness's own words. That's an actual requirement, in the witness's own words. If that's a requirement in international arbitration, it's more observed in the breach than in the observation. And one of the reasons is in international arbitration, you get a lot of people from other language groups than say English or the language of the arbitration. And you know, you do want to help them along without interfering with the content of what they say. Sometimes you get like an absolute chasm between the use of the language in the witness statement on the one hand and the witness's use of language at the hearing orally. I once had witnesses from a culture which is very, very, let's say, respectful of authority and keen to follow rules. I won't say which it is because that might be invidious. At any rate, I told the witnesses, look, guys, I've actually, you know, kind of massaged your language, right? Because you're not that strong in English. You know, I'm concerned that you're going to be asked whether I influenced you. Now, I want to say there's a distinction between use of language in arbitration, not in English litigation. There's a distinction between the use of language on the one hand, and then on the other hand, the content. And so you want to say, guys, that all counsel did was assist us with language. So when the arbitral tribunal got these witnesses before them, and you know they could barely speak English, the tribunal asked, "Is this witness statement in your own words?" And of course, they all said, "Of course it is," which looked, I think, very, very implausible. I think it unfortunately did damage to our credibility. But there you are. So that's a very firm rule in English litigation. Huh? The witness statement is not only the witness's evidence, but it's in the witness's own words. Another rule in English litigation concerning witness statements is that they have to contain at the end this thing called a statement of truth. And the statement of truth is actually dictated. Its content is dictated. I'm going to read it to you. Ready? Because it's pretty hard hitting and pretty extensive. Here it is. I believe the facts stated in this witness statement are true. I understand that proceedings for contempt of court may be brought against anyone who makes or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth. Okay, you don't get that in international arbitration. As Harris mentioned, you're going to get, if you like, the witness saying, what I say is truthful. What are you going to do about it? No, basically the witness is going to say at the end of a witness statement, this is truthful. This is what I believe. Yeah, but it's not as, if you like, formulaic as in English litigation witness statements. And in arbitration, with some few exceptions, you're not going to get anything like contempt of court. Does everybody know what contempt of court is? Contempt of court is a criminal offense. So the judge can actually say, you're in contempt of court. Off you go to Wandsworth prison. Or I don't know, perhaps you don't go to Wandsworth, but you go to somewhere similarly or you know, slightly unpleasant. You know, you're incarcerated. So there you are. So those are some differences. Anybody want to add any further differences? There are others. Yes, Harris?
Actually, I would like to stress on the fact that, as you already said, is that in arbitration, because we are in an international environment, one is not using a specific set of rules which applies in specific jurisdiction. So the important thing is to be able to communicate to the tribunal what you really want to say. This applies to the lawyers and to the witnesses. So, of course, what matters is also which is the background of the tribunal. So the actual arbitrators, where do they come from? What do they usually do when it comes to, you know, the process, the procedure they follow? So in that sense, agreeing also on some of these, you know, form issues of witness statements may be an idea at the outset of the arbitration, so that everybody knows what is expected by the tribunal. So just we should forget national traditions. I think we should try to work in a comparative way, but at the same time take into account who are the arbitrators.
Yeah, absolutely. It's excellent advice. Yeah, Johannes?
Maybe just a brief follow-up on what Harris said. I think the key difference between arbitration and civil litigation is that not so much in the rules, but in the policing of the rules. Because in state courts, you get in trouble, and in arbitration you rarely do. So I think the key is what Harris just said, that you try to communicate with the tribunal, and whatever's effective is sort of allowed. Of course, you can agree on certain rules at the outset, but they should also be tailored with that perspective, trying to get something useful to the tribunal, rather than having certain formalities observed that may be important to some traditions, but not to others.
Yeah. Okay. Should we move on, or is there something more to say? I'm just looking at the time. I mean, we've used 46 of our minutes, which is just fine. There are two other questions. Cesar Fernando Hermosa, I think we'll take your question when it comes up. What measures, an important question, what measures can be taken to mitigate the risk of coaching counsel working on the witness or bias? So we'll listen for the answer when it comes, and we'll explore that very important matter. And anonymous attendee, importance of place of virtual cases and implications for evidence, please. So how does the fact that the hearing is going to be virtual affect what you do in preparing witness statements and interviewing witnesses? Yeah, do you want to, should we address that now? Hearing's not going to be in person, it's going to be virtual. What's that going to do for you when you're preparing a witness statement?
Just a quick reaction. When it comes, because I understand the references to the lex arbitri, really. So in a virtual hearing, there may be an issue with that, but not necessarily, because if there is a seat of arbitration, there is a lex arbitri, even if the hearing is virtual. So and then the rules, so I'm honest, that apply dictate perhaps what's going to take place. And of course, if parties agree, for example, on the IBA rules, which are soft law, then you know already what's. So I'm not sure that there is a much of a difference. I understand that this question implies that because of the virtual hearing, perhaps I'm not sure about the lex arbitri, but I'm not sure that this is the case. That's my initial reaction. I don't know if I missed the point.
No, I think it's it, yeah. I would say, honestly, the practical answer for me is that you take more liberties on the witness statements when you know the witness isn't going to be put right in front of the arbitrators physically. There are two things. When the witnesses aren't put in front of the arbitrators physically, they're less intimidated. When people are intimidated, they tend to cracher le morceau, as the French say. They tend to, say stuff that's going to betray what they really mean, That's part of the, let's say, the mechanism of cross-examination. The witnesses are placed at a psychological disadvantage vis-a-vis the judge and the cross-examiner, and they tend to say stuff that is uncareful or imprudent. Yeah, so I'd say I'm a kind of a wizened old counsel, so I just kind of do what I can to win within the ethical rules. But doubtless, I'm always thinking, this witness is not going to get pushed around if there's not a real hearing. I shouldn't say real hearing, a physical hearing. So that's something. But otherwise, the mechanism is similar. When you have a virtual hearing, you have the arbitrators always taking precaution, as suggested by the IBA rules, which Harris has referred to, which I've posted a link to on the Q&A, that precautions need to be taken to make sure the witness is not being coached while he or she is testifying. I was in a hearing where I just disappeared for a moment, like this sort of thing. I was looking at my notes, and the counsel barked. So the witness, the arbitrators barked at me, "Mr. Landau, where are you?" And I was like, "I'm here," honestly. So there's that kind of policing, and with the consequence that you get similar circumstances in virtual hearings to what you get in physical hearings. There are three follow-up questions to our English witness statement question. I think we'll take two later. They're all excellent questions, but the first one is, why don't you actually let the witness write in their own language when they're really, really bad in the language of the arbitration, English in particular. Yes, yes, absolutely. You're right. It's good, but it's kind of prophylactic. It creates a barrier between the tribunal and the witnesses, and I think it makes the evidence less authentic. Less, I don't know, compelling. So my instinct is always to get the witness to speak genuinely in their own language. It just looks so much more effective. And often the arbitrators aren't speaking their first language either, So that's why I do that. But you're right. There's a stage at which you want the witness to be testifying in the witness statement in their own language. There's a stage where they just can't work with English. But in international business, people tend to be able to work in English, French, Spanish, Russian, Chinese. The big languages. Yeah. So you tend to get stuff in that language, and I try to keep it all in the original language. Another reason is because it slows things down horrendously when you have translation. It's just so slow. You know what really dictates the pace of oral hearings? It's how fast the interpreters work. I mean, they really, I don't know if they're all unionized or something, but they all work about like 40 minutes at a time, and then they take a break. So it really is, if you'd like, the critical path in terms of the advancement of international arbitration hearings, how fast the interpreters are willing to work. Usually you get a whole kind of squadron, you get a peloton of interpreters, because they don't tend to be able to work very long. I shouldn't criticize, I'm not a good interpreter myself. Anyway, let's take the other two questions a little later. And I propose we move on to our third topic, which I'll invite Johannes to lead. It's the relationship between counsel and the witness. Johannes, please.
Thank you, Philip. I was asked or given by Philip 2 sub-questions to deal with this topic, relationship between counsel and witness. And those 2 sub-questions were, number 1, what is the role of counsel? That's something that already came up in the questions. So we deal with this now. And the second sub-question was, is any influence of counsel appropriate? Now, it is probably easier to start with the second sub-question, is any influence appropriate? And we can quickly conclude that this may be asking the wrong question to begin with, because the question is not so much whether any influence is appropriate. Any interaction between counsel and witness will influence the latter, so we just can't exclude that. We could, of course, try to exclude any contact between counsel and witness, at least in advance of the hearing. That is done in some civil procedure systems and state courts. However, I think this is, I put it bluntly, impossible to police in international arbitration. So I wouldn't go down that route, because if we have a rule that you can't implement, then better not have that rule to begin with. Even then, the witness would be influenced by counsel during examination at the hearing to some degree. So there is always going to be influence of some kind. We actually organized a seminar on this issue last year in the firm, and a psychology professor told us that even memories can be reconstructed. So it's, even if you ask the right questions long enough, the witness will remember certain things that may never have happened. It's not that you indoctrinate them, they basically indoctrinate themselves. And that can be very effective, but of course, it's not really what we would try to do in the context of judicial proceedings. And there may be one side comment about the reliability of witnesses' testimony and what common and civil lawyers think about it. I think there's now overall agreement around the world that witness testimony is unreliable, even in the common law world. I mean, a lot of this research comes from England, actually. The barristers obviously not shouting that from the roofs, because that's their livelihood that might go out the window. But common lawyers are very well aware of this, and they also think that witnesses have to be taken with a pinch of salt, a witness testimony. So influence of counsel on a witness is a fact of life. The question is just, how do we deal with this fact of life? And there we have to think of 2 sides, namely the influence you exercise on your own witnesses, and then also the opposing counsel's influence on their witness. That's also something we have to think about, because there we have no control whatsoever. As Harris said before, about anything goes in arbitration. So again, it's difficult to police. You can put down rules, don't coach, don't do this, don't do that. It's again difficult to police. That brings me back to the first sub-question. What is the role of counsel? And there we can distinguish, I think, between the two sides. So what is your role with respect to your own witnesses? And what is your role as counsel with respect to the opposing side's witnesses? The latter, the second, is again probably easier to start. What is your role with regard to the opposing side's witnesses? In a nutshell, it's you try to discredit their testimony. Since we now know that such witnesses might believe in whatever they say, irrespective of whether they have actually witnessed it, and since we can't police the type of influence the opposing counsel is going to exercise, the safest approach here is usually to confront the witness with unimpeachable alternative evidence. That, of course, is most of the time documents, can be common sense, publicly known facts, where you tell the witness, well, come on, do you really believe this? And then they get red in the face, and of course they don't. So that's your role as counsel with regard to the opposing side's witnesses. With regard to your own, you basically anticipate that the other side is going to do more or less the same. I would argue that the role of counsel with regard to your own witnesses is primarily to make it unassailable on cross-examination, namely by ensuring that it is consistent with unimpeachable evidence. So consistent with documents, consistent with common sense, with publicly known facts. If you ask the witness beforehand a question about whether they really believe this and it makes sense, they might realize that it's nonsense what they're talking about. And then they will change their testimony, not in the sense of making it up, but in the sense of making it more plausible. I think that's in general terms what you're trying to do as an advocate. You try to make your own testimony plausible to the tribunal, because otherwise it's just a waste of time. And I would say that this is all irrespective of whether you as counsel like the content. When you're talking to the witness and you get out of the witness the wrong content, then think about a different litigation strategy, a different legal approach, maybe a different witness, or maybe settle the case. It's not really helpful to try to tamper with witness testimony in the long run. Because, and that is getting me already to the end of my initial remarks, we have yet not talked about one important actor in this game, and that's the arbitral tribunal. I would argue that any attempts at engineering the content of witness testimony are bound to fail in any event if the arbitrators are attentive and if they are aware of the limited reliability of witness testimony, with which most of them are in any event. And then both sub-issues like the role of counsel and whether any influence is appropriate or the degree to which influence is appropriate, they are of secondary importance for the proper functioning of arbitration. It is at the end all about an attentive tribunal, and that is a tribunal that is taking its task seriously. Thank you. Back to you, Philip.
Thanks, Johannes. Comments from the other speakers? Yeah, I think we've heard, was it from, I think it was from Baptiste, we heard that it's probably best, to put everything into a witness statement, even where there's material that could hurt your case. I mean, I often find a witness is helpful in some.
Not from me, no. I actually disagree with that.
Okay, yeah. I don't remember. Maybe I misheard that from someone.
It's okay.
Else, yeah, but I actually, I mean, I constantly select material that helps and omit material that doesn't. I was wondering if that's your general practice as well, speakers.
Mm-hmm. Indeed, I didn't say that either, Philippe, but I tend to agree that I prefer to bring out whatever problems or issues that can be perceived as problems with relation to the witness themselves or with their testimony. So rather doing that than having that brought to the attention of the tribunal by the opposing parties' counsel on cross-examination. So, because in my view, treating those issues that can be that the witness can be perceived as biased or it gives you an opportunity to treat that flaw, let's say, and try and mitigate it. Yes, I mean, because if it has come to your attention, it would have certainly come to the attention of the opposing parties' counsel. So it's always, in my view, in my experience, a much harder task to try and do that at on redirect. So to try and do the damage control after the damage has already been done. So if that is practicable, try and address whatever problems you believe there are with the witness or with their testimony. I mean, we're talking about witness statements here. It's more difficult to think of yourself doing that in writing, putting it in writing in black and white, because normally I would do that in the examination in chief, so orally. But I mean, definitely, yeah. Don't let the opposing parties' counsel bring that out. Do it yourself, yeah.
I think it's also a bit an issue of plausible deniability. If the witness can plausibly deny knowing anything about it, then you're safe to exclude it. If the witness has witnessed certain things and the other side knows about it because they wrote an email or they wrote a report, then it's very difficult to not address it. And then I fully agree with Jose. Better deal with it up front, and then you can still spin it, rather than let the other side sort of find out about it. And then, I mean, when I talk to witnesses, I always want to know the whole truth in the beginning. And then if it's really impossible for that witness to steer clear of those things, I might get another witness or I might change the legal strategy or something. But I wouldn't sort of take snippets out of someone's memory that fit my story and the rest ignore, because that will come up eventually.
All right. How about this? You get the witness's statement, their draft, okay? Because you just say to the witness, go off, draft what you know. And then you see that there are bits like sections 1, 7, and 21 really, really hurt you. Is it unethical to remove them?
I mean, if obviously it's not a let's see, unethical. I mean, the party you're representing is calling that witness to, in a way, support their case, right? So, of course, you're not going to, because I mean, you said that before, Philip. The witness is going to testify about whatever they saw or thought at the time of the event, that is, for whatever reason, relevant to the issue in dispute. If this is something that cannot be brought out on cross-examination, I would just make my case, obviously, to the witness that is not relevant because it's not helping your case. I mean, why leave it in when it's certainly going to be counterproductive? Yeah, I do not think it's unethical. I'm saying this, and I honestly think that. As I think Johannes was saying, just trying to steer clear of that part, and of course, if the opposing party's counsel bring it out, then you will try and do something redirect. But I mean, sorry, I'm just to finish my comment. It's not that the witness sits down and writes whatever comes to their minds, right? I mean, you are going to be interviewing the witness, okay? So you will be able to ask the right questions. So those section 1, 7, and 21 shouldn't probably be in the witness statement in the first place, because you wouldn't have asked those questions, in my view at least, no?
Yeah.
But sorry, just to add to what Jose was saying, I think it asks a wider question, which is, I mean, when do you learn about something that is going to hurt your case, whether you actually elicited that evidence from the witness or not, how do you deal with it? I mean, in my experience, and I've had the unfortunate experience of learning in between one witness statement and the reply witness statement of something that it was really hurting our case. And one of the reasons why that sometimes happened, as Johannes said very rightly, is that sometimes witnesses convince themselves of a story, and actually a whole organization convinces itself of a story, which is completely different from what actually happened. And so you have, as counsel, as much as you can, and as diplomatically as you can, actually go into the truth of the matter, which is not always easy, and which can happen in waves. So having had that experience now, I always assume that unhelpful stuff will surface one way or the other. So it's better to learn about it when it's in a draft, as you put it, Philippe, in a first draft, so that you can address it either, as Johannes, you perfectly put it, either you address it with another witness, if it's really important and that's going to surface, or you change your legal strategy that can actually push you towards settling or towards making another argument. But you don't have to leave it in my view, you don't have to leave it in the witness statement, but you do have to address it one way or the other. Because as you said, Jose, it's really the worst thing that can happen is that surface said they're hearing, that you've got no response for it, either in documents or in another evidence. But in my experience, it can happen. Very, very damaging experience evidence can surface, including when you've done your homework. So better assume that it's going to surface and you're going to have to deal with it one way or the other.
Yeah, that's a very good point. Just quickly, what Baptiste said, because you have to plan ahead for redirect. You cannot expect to be able to just work with the notes that you take as the opposing party's counsel is doing the cross-examination. So it's important to plan ahead really well what you believe is going to come up on cross, and then of course supplement that with whatever actually happens on cross. But planning ahead is definitely a very, very good advice.
Okay, thanks. At this stage, we can address Cesar Fernando Hermoso's question. What measures can be taken to mitigate the risk of coaching counsel working on the witness or bias? I'd like to suggest one, and it's this. When I look at the witness evidence against me through the witness statements, I'm always looking for this, what the witness probably knows and what's missing. Yeah, that's the biggest control. So if I see a witness who is, there observing stuff and he or she's not testifying on something really big, I know they're hiding something. That's a really good way of policing counsel influence in the sense of leaving stuff out. Or there's a witness who's really, really important, who knows everything, and he or she is a conspicuous absentee. Then I'm going to ask, why is that witness not there? Often you get cases where the other side has no witnesses, and you say, why? You ask the tribunal, why? Why are there no witnesses? It's because they know the real story and it hurts. Yeah. So that's a really good way of policing counsel influence. Anybody want to suggest other mechanisms? cross-examination in general, you always get the question, is this your own statement? Is it these your own words? You know, that sort of thing. And, you know, you can really probe. Did you organize this? Were the things that you put in and were left out upon the advice of counsel? How many times did you meet counsel? Where did you meet counsel? Et cetera, et cetera. You know, you can really probe and get a sense of the degree to which counsel has influenced a witness. And because of that, in the knowledge of that, you know, you're going to be very careful in influencing a witness, because the witness is going to be faced with this sort of questioning, both from the tribunal and opposing counsel. Okay, so there are various measures which do help to deter counsel influence on witnesses. I propose that this. Yep.
And of course, as Johannes said, you can actually put some sort of those rules in procedural order, but the problem is, can you actually police it? I had a case recently where the CPR rules of the UK rules of witness evidence and against witness preparation were in the procedural order, but of course the two counsel on each side were US lawyers. So first of all, it's contradictory because US lawyers can coach up their witnesses and often do. But so of course, I mean it's beautiful. It's in the procedural order, but how do you make sure it's actually efficient?
Yeah. Okay. Thanks, Baptiste. I think we should move on to our next section in view of the rapidly disappearing time. This is on selecting witnesses, and this is Baptiste who's going to introduce us to the topic. Baptiste.
Thank you, Philippe, and thank you again for the organization and putting the roadmap together for this important topic. So I'm going to be try to be very concrete in my remarks to give our audience a practical roadmap about, one, selecting witnesses, and second, preparing the witness statement. So first, selection of witnesses. So we've determined very arbitrarily three selection factors, three main selection factors for selecting witnesses. One is willingness to undertake the role of witness. Second is knowledge of the relevant events. And third is the credibility of the witness. How do you, I mean, you obviously want a witness that doesn't look uncomfortable and that is not to be believed by the tribunal. That is difficult to be believed by the tribunal. So taking those selection factors into order. So willingness is actually a very important aspect, because you can have in your own head selected fantastic witness, but if they don't want to testify, then you're stuck. So it's obviously something that you should ask during the first interview. It's my practice to ask about it during the first interview with a potential witness candidate. Because even if that's not your first choice, but that is the only person who is willing to testify, then you have to work your way around it. So in my view, again, in my practice, I tend to schedule multiple interviews with multiple organization officials, so that I am able to have a plan A for one witness, and a plan B and a plan C, and sometimes a plan D. Because if everything falls down and if none of my first three options are willing to testify. So during that first interview, and when you get to what it actually entails to be a witness, you should be very precise about the different responsibilities of witnesses. So obviously that witness will have to submit a witness statement, will have to work on a first draft, review back and forth with counsel, and sign it. They will have to accept that their credibility and their recollection of events will be questioned in writing by the other side via the submission of a statement by the other side witness. They will have to accept that these people that they may have considered as colleagues or friends during the contractual relationship might question their credibility and their sincerity in writing. and that can be quite hurtful to humans. You will have that also, the responsibility falls on them to, as the case may be, produce a reply witness statement, which repeats the same type of work as the first draft. They will also have to understand that they might be called to testify, and they might also not be called to testify, and don't take it personally. If you're not called to testify as a witness, it happens. It doesn't mean that you're not being truthful and that nobody is actually interested in your evidence. Then obviously you have to explain to them what the cross-examination process entails without, in my experience, frightening them too much, because you don't want to give them all your war stories in the first interview, because otherwise you might get people to scared about being involved at all in the arbitration. Then you have to be prepared for back and forth with the witness. I've had a few instances a witness agreeing to participate as a witness, and during the process of writing the witness statement, being a bit touchy about actually participating, and sometimes reneging their commitment to participate. So you have to be prepared to persuade them that it's going to be fine and alleviate logistical or substantive concerns they might have. And in my view, again, that's not a recipe for a potential disaster of a witness that doesn't want to appear, or that no longer wants to be part of the arbitration once they have received the other side's response witness statement. But it's a good start. So the second selection factor is knowledge. You have to ascertain the knowledge of your candidates for witnesses, the knowledge of the events. And how do you do that? So in my practice, I just start by pulling out all the documentation involving the potential witness, whether they are sender or recipient of an email or document or letter, whatever, pulling out the meeting notes where he or she was present, and also the documentation which they could have known of at the time. So do that in chronological order, so that you get a sense of the context of the witness's involvement in the dispute. And then when you are in the first interview, you start the interview chronologically by asking his or her knowledge of the key facts, obviously you ask that with your own knowledge of the documentation in mind. In my experience, it's not necessarily helpful to show documents to refresh the memory at the first interview meeting, because again, if you start by showing documents, you will inform the witness about what they should know, and you won't be able to test their knowledge, and you also won't be able to test whether he or he can say, I don't remember, or I don't know. It's good to have a witness that knows when to stop about creating their own evidence. So that's a way to test that. Obviously, it goes without saying, but you never want a witness that just makes things up, and not to look ignorant. It happens, but you don't want that. So then the third element is credibility. And in my experience, that's the most difficult thing to ascertain. Goes without saying that some people look more comfortable. It's not equivalent to credible, but sometimes its two notions overlap. Some people look more credible than others. It also goes without saying that the exercise on knowledge, which I was mentioning seconds ago, will go a long way to assessing the credibility of a potential candidate for witness. One element that as counsel you might think is important is whether you take as witness the most senior person in the organization, whether that's a recipe for having a credible witness. In my experience, that seniority can be a problem, because senior people tend to be reported to instead of having direct knowledge of the events. They also have a greater, as we were mentioning, a greater interest in the future or in the life of the company. So they will have a tendency to reconstruct their memory to align with the objectives of their company. But of course, sometimes it's also interesting to have the experience of the CEO, for example, because you want a view or you want some evidence on the commercial strategy behind the conclusion of a contract or stuff like that. But so I would advise against getting fixated on getting the highest ranking official at all costs, because what matters is really that the witness has direct knowledge of the events. And last but not least, language ability is very important. You want to be very clear about which language is more appropriate for your witness, so that you can act accordingly. Meaning if they are not, as we were mentioning, in my experience, if they are not fully capable of writing in their own words the first draft in English, then fine, write it in your own language and we'll provide a translation. That's much safer in my experience than just putting down their throat an English witness statement, which they are not comfortable with. And so maybe I'll just jump into the second topic of interviewing the witness.
I think it's a good idea.
Yeah.
Yeah.
Exactly. And so now that you've identified, again, it's not bulletproof strategy. It can always happen that there are issues, but now that you've identified the witness or the witnesses that will testify, there are a few elements that are of logistical nature which must be dealt with to make sure that the witness statement is actually helpful to the tribunal. And at that juncture, I should mention that I'm speaking from a French lawyer's perspective, where, and in French, we can assist in the preparation of witness statements and witness evidence in general, much more freely than English lawyers do. So, first question is, do you interview the witness in person or virtually? It used to be that you couldn't actually do that virtually when Zoom or Teams didn't exist, but that's quite long ago. So now I think it depends on budget for sure. It depends whether you have the budget to actually travel to the location of where the witness is. It depends on the availability of the witness, whether it's easy to reach him or her. I've had a few cases now in Africa where the witness is actually an engineer on a project in the middle of a very remote area. So can you actually go there? I would say that ideally the first meeting should be in person, because you can then better assess the demeanor of the witness and again the credibility of the witness. Then other meetings to continue on the preparation of the witness statement can be done virtually to fine-tune the witness statement. Another point militating in meeting your candidates, at least at the first meeting in person, is that you can then better see the environment in which they operate. You can better see the relationship with other stakeholders, let's put it this way, in the project or in the dispute, including the other side's potential witnesses and or the other side's employees. Because you never know, it's difficult virtually to assess whether your witness actually has personal relationship with the other side's employees that they are too afraid to tell you, or that go without saying for them, but that you don't know. So that you can more easily see when you're going on the ground. Then the second question is what to instruct the witness to pull together for the witness statement. So as I was saying, my practice is to put together a binder or folder of documents which the witness authored or was recipient of or should have known or could have known at the time. Then you instruct them to review these documents. Again, in my experience, they rarely do that homework in its entirety. So you have to be prepared to pull the documents for them. Then you give them a roadmap of their evidence, which issues you want them to have to give evidence on chronologically. Then you will run through those different issues with them during the interviews to make sure that they give their exact recollection of the events, and that also you don't miss some event that you need evidence on. And when they don't remember, you can point them to a document to refresh their memory. But in that instance, in my experience, it's often good practice to say in the witness statement that during the course of the preparation of the witness statement, they were shown X document by counsel, which they didn't recall at the time, but in which they are mentioned, something like that. Then how do you test the witness knowledge during the course of the preparation of the witness statement? Again, as I was mentioning, in my experience, it's counterproductive to force a memory down a witness throat, including with a reference to documents, because that might backfire at the cross-examination stage. So you want your witness to be confident enough with their statement to be able to withstand cross-examination. So if they don't know about it, don't reconstruct their memory by asking the question 3, 4, 5 times or showing them the document. If they are reluctant, maybe there's something else behind it, as you mentioned, Philippe. So work with that uncertainty to mitigate its risk on your case, but don't force a witness to give evidence on something they're not comfortable with. And then the last point, which is also something you must consider, is should other persons be present when you're interviewing the witness, either their colleagues or some other person. I mean, you tend to, in my experience, I tend to favor talking one-on-one with the witness so that their colleagues don't influence their recollection of events or their evidence. But that's ideally because it's not always possible. Sometimes you at least have in-house lawyers sit in those interviews, your clients, in other words. So, but you have to, especially with in-house lawyers that don't have experience with the litigation or arbitration process, you have to inform them and educate them about potential problems that would be caused with them intervening too much or polluting the recollection of events of the witness. So you have to tell them that they obviously as in-house lawyers, they have the interest of their organization to safeguard and mitigate. But that's not always a good idea to impose on a witness evidence, on a witness recollection, the case strategy of the client.
Yeah, thanks, Baptiste. Can you ask leading questions when you're interviewing witnesses?
I rarely do. Unless it's for clarification purposes, for example. I mean, I've had long witness interviews where when you speak English, obviously, and the other side also does, but there are language barriers or language difficulties. So you do have to ask leading questions just to get to the bottom of what the witness wants to say. But in my view, again, it's all about having the witness be comfortable defending his or her own evidence and not being influenced too much about what you want them to say. So at least in the preparation of the evidence, then you have something else, which is called cross-examination preparation, which is a bit different to me, where then you get them to go through the cross-examination process, and then the rules are, I mean, the rules, there are no rules, but the principles are a bit different. But when you are constructing with them, building up witness statements, I think you have also to sort of trust that they will do the right thing, and so not shape their evidence too much.
Yeah, I totally agree. So it's not a great idea to ask leading questions because, as Baptiste says, and Johannes said it too, you want to know what the witness knows. And if you're asking leading questions, you're basically supplying the answer. You're suggesting the answer. And then you don't know what the witness knows. And then it's going to come out in cross-examination. So you want to know. Is it unethical? Yeah, it's a type of influence, but you don't get caught. You can never get caught. So I'm sorry to be cynical, but everybody does it. I was once walking through the airport in Geneva, and there was this advert for watches saying, in order to break the rules, you need to know the rules first. You need to master the rules first. Well, if you know that leading questions, the reason why, in some circumstances, leading questions aren't permitted in cross-examination. Well, in cross-examination, it's because the evidence you're going to get is no good, but the judge is going to believe it, because it's going to see the influence of counsel on it right in front of him or her. But if you know that's what's happening, then you realize there are circumstances where you can ask leading questions effectively. And Baptiste suggested it. You try to get the information out of the client. Sometimes it's the only way. Because they just don't know what you want. You can't say stuff like, "You were in Paris on the 22nd of May, 2024. Tell me what you saw." Honestly, it's too open. The witnesses just don't know what's relevant. That's the one thing you realize once you've studied law for even 2 weeks. Most of humanity doesn't know what's relevant. It's like the one thing that lawyers do better than anybody else, especially engineers, is we know what actually matters. Because our whole discipline is to actually separate the wheat from the chaff. Anyhow, that's what I want to say. We are dangerously short on time, and therefore, although there's much, much more to say on these two topics, I think we're constrained to move on to the next, unless there is, a groundswell of opposition. The next topic will be led by Harris, and it's drafting witness statements. Harris, please.
Thank you, Philip. So, as we don't have much time, I will try to be as short as possible in my presentation. So essentially, the question of drafting is important in the sense that it is very practical. It's the most practical aspect, perhaps, of what we're talking about now. So the first thing is the formatting. I mean, what's the formatting of the statement, and I mean, I think that on the basis of what we have heard, one can easily say that the most important thing is to make sure that what is written is clear, I would say detailed, and it represents exactly what the specific person knows about the case. And it's important that it is detailed because this will allow the tribunal to understand also the credibility of the witness, and also be able to understand the case in general. So in that sense, this is critical. Another thing is that usually these statements are written in the first person, singular, and the form is usually narrative. So this happened, then and that, and there's no logarithm. There shouldn't be any logarithm, because if there is any, most probably this will show that the role of the lawyer was very, very strong in the preparation of this statement, and this does not help. Usually, one would expect to see some further corroborating evidence together with the statement. this adds credibility, I believe, to what is written. Now, who does the drafting? We have said that the role of the lawyer is to help the witness, not replace the witness in writing the actual statement. That's clear. So essentially, there should be a cooperation, there should be assistance, but the outcome should be the statement in the witness's own words. So in that sense, this is how one would expect to see a statement written. Now, what are the topics that are covered? We talked about the direct and the indirect knowledge. Evidently, direct knowledge is what matters. This witness should refer to what she or he knows personally. And I think that was what has already been before about the person who testifies. It makes sense to be people on the ground, not so much people that were informed about what happened. So the top management, not so much, rather than the people that were on the ground or in relation to the dispute. So that's important, and for that matter, these people know personally what the facts are, and they can reproduce them in the statement. And this, of course, adds credibility. All these issues, I believe that they should be approached also in relation to the burden of proof rule that is followed by the tribunal. As we know, in the various traditions, there are systems, different approaches. So, I mean, in the civil law system, usually you expect to see a full judicial conviction. In common law countries, in many procedures, you have a preponderance of evidence, where what one needs to prove is not as strong as in the case of civil law jurisdictions. Of course, here in arbitration, as we said before, one needs to see who the tribunal consists of, and also if there are any guidelines of the tribunal in the terms of reference or any other similar document that will be created at the outset or agreed among the parties. So, I mean, essentially, that will also guide the lawyers as to what is expected in the witness statement, and that's their role, I believe, mostly, rather than write the statement instead of the witnesses, which is not a good practice. So, I mean, in many respects, arbitration usually one expects an arbitration to have a clear and convincing evidence, which is something in between the two standards of proof that one encounters in common and civil law jurisdictions. Having all that, I would like to finish with a question of language. I discussed that before, and not only me. As we all agree, it's important that the person who testifies knows the language well. If this is not the case, it's safer to have this person testify in writing and, of course, orally at the hearing in her or his own native language, or in a language that she or he understands and speaks well, rather than use the language of the proceedings directly. Of course, in that case, one needs a translation of this statement. One does not need to have necessarily a certified translation. Much depends, or I would say everything depends on what are the rules of the tribunal. If there are not any rules, I couldn't go to something very strict. It's important to have a translation which is accurate and correct, and that's about it. So this is what I want to share with you at this point. Thanks. I think you're muted.
Sorry, I apologize. Yes, thank you very much, Harris. Many questions, but I think in the interest of time, we should move on. We have two further topics. Maybe if there's time left, we can add commentary, and answers to further questions at the end. So let's please move on to Johannes's remarks on perception witnesses with specialized knowledge.
Yes,
Johannes.
thank you, Philip. This is a very specific point and shouldn't take too long. It basically came up when Philip and I brainstormed a couple of weeks ago about this seminar, and I did some name dropping and mentioned the fact witness with special expertise that we know in Switzerland, also in this German court proceedings. In German, it's the Sachverständige Zeuge. And we quickly realized that not all jurisdictions know about this, so we just wanted to present this aspect. The traditional distinction that we know from arbitration is obviously fact witnesses and experts, also called expert witnesses. And what's the key difference? I mean, both know something, hopefully, but I think the key difference is fact witnesses can't be replaced. They have seen something and only they have seen something. That's the issue with the direct and indirect knowledge, of course, but ideally they have seen something and only they can then tell us about it. Expert witnesses can be exchanged. If you have someone with the same expertise, it doesn't really matter who the individual is. Experts can testify, obviously, about a lot of things, can also be a fact, like was a document forged, can be about technical specifications, can be about legal matters. That's all issues that experts can bring into the proceedings that arbitrators do not know themselves. And then there is this fact witness with specific knowledge, a sort of hybrid witness that we know in Swiss court proceedings. You have here the provision 175 of the Swiss Code of Civil Procedure that talks about witnesses of, it talks about expert witness. That is not a very good translation. It is with fact witnesses with special expertise. They are normal witnesses, so they can't be exchanged. They have witnessed something, but then they also have some expertise that the tribunal, or here the court, would want to make good use of. Just reading it out, the provision says if a witness has a special expertise, the court may also ask him or her questions about his or her assessment of the facts of the case. And that is basically the reason why we have that provision. It says that the court can ask the witness to assess the facts of the case, what would otherwise be the court's or the tribunal's task. You may say that sort of goes without saying. We need that special provision because that goes obviously beyond what is normal fact witness testimony. The court or tribunal asks a fact witness to help them with something. In reverse, the more important aspect here is, for me, what is not permitted. The court may not present additional facts to that witness. That is key. The witness has certain observations, and then the court can ask the witness what he or she thinks from the expert perspective about these facts that this person has witnessed. For instance, you have seen a plane crash, and then if you are yourself a pilot or an aircraft engineer, you may have certain observations to make on top of what you have witnessed. But it is not allowed to then tell the witness something that they have not witnessed. Like you quote from the black box, or you tell something about flight schedule or meteorological conditions, something the witness would not have witnessed him or herself. So that is not permitted in this context, which gets me back to arbitration. A few reflections. It is probably safe to say that witnesses of fact with special expertise are regularly used in arbitration, even though we're not really thinking of it in these terms. If we think about an engineer that Baptiste was mentioning in the jungle, that has installed a machine, that is, of course, a fact witness that has seen what was going on, but is also an expert in that trade or in installing this type of machinery. And that is where I think the problem sort of starts. It is probably also safe to say that often we do not really distinguish, or tribunals in particular do not distinguish, factual testimony of these people and expert testimony. They frequently ask them about general issues, try to educate themselves, the arbitrators educate themselves with this fact witness, and they just ask them about general issues of their trade, how machines work, how often they have seen this happen before, how they do this normally in their company. That is not fact testimony. It is expert testimony, but going beyond what that person has witnessed, at least witnessed on that particular in that particular context. And I'm asking myself, and I'm not going to answer that question, but the question would be, should we learn from state court systems and police this issue a bit more carefully, rather than let any questions being asked to fact witnesses that go beyond the mere fact issues and basically draw on their expertise without them being really called as experts. If they are called as experts, that's fine. But if they're not called as experts, in particular, if the other side has not been able to bring a counter expert, is that really fair to our concerned to ask these fact witnesses also expert questions? That would have been my comments. Back to you, Philip. You're still on mute.
Apologies. Thank you so much, Johannes. Very, very interesting phenomenon in Swiss civil procedure. I have a sense as a Swiss lawyer how the Swiss courts would treat this and why they'd want this institution. How do arbitrators treat this sort of specialized knowledge from the mouths of these specialized witnesses? Is it given extra weight, or is there a rule? How do you think they should deal with this?
Well, in my experience, I believe arbitral tribunals tend to take the opportunity to ask these let's call them expert witnesses questions about whatever the expertise is, and that are not necessarily related to the facts that they witnessed or the knowledge that they had, and that was the subject of their witness statement or basically their testimony in the first place. So you could say this is useful, but at the same time, it can be dangerous in my view, because it undermines the forcibility. Because it could be that the other party has called also a witness of fact, okay, but not with the similar background, not an engineer, for instance. So obviously, I'm sure that in an arbitral proceeding where the testimony of an expert witness has some relevance, there will also be expert reports. But it's true that those maybe over 100 pages long. So that's why I'm saying that I've seen many times arbitral tribunals very interested in knowing, in learning from that expert witness that is there at hand. How they see a certain matter of a more technical nature. So it's useful, but at the same time has to be controlled, and it can impact the forcibility that I would expect to have in arbitral proceedings.
Yeah. Okay. Any other comments on this issue?
Yes, Philip. As Johannes said, I mean, arbitral tribunal, in my experience, will tend to ask some contextual questions to those kinds of witnesses to know a bit about the trade, as you said. I had a case relating to IT infrastructure where clearly one of the witnesses was also an IT specialist and he had put together the infrastructure. So it was interesting to the tribunal to ask about the trade, but problem is that as a tribunal, you cannot really, in my view at least, put too much weight on the expertise of the witness, because they are not bound by the same obligations as expert witnesses are. There's no obviously statement of independence or obligation to update their views in light of new facts. So it has to stop at, I want to know a little more about what your trait means, what it means to I mean, what your skills are, but I can't really take you seriously as an expert witness because you don't have the same obligations as they do.
Yeah, that's a very, very good point. There's so much more to say on this. We're short on time, but I am going to mention that, yes, I think there's a huge tension between, on the one hand, getting at the truth, the obligation of the tribunal, and on the other hand, equality between the parties. If you happen to have that witness who's the engineer watching the plane go down, we're lucky for you, you're in this asymmetrical situation. At any rate, I'm afraid we're going to have to leave this very, very fecund topic aside and move on to our next and final topic, which is very important and also very interesting. It's Jose speaking on strategy and witness statements. Jose, please.
Yeah, thank you, Philip. This topic is concentrated on two subtopics. I believe we've covered enough. One of them, which is basically anticipating cross-examination, and we've talked about the importance of bringing out whatever may weaken your witness or his or her testimony. And so if you allow me, I will come back now quickly to what I said before that I will leave for later, and is the alternatives, what alternatives there are to witness statements. And we've been talking so much about witness statements. Maybe you can allow me a few minutes to speak about those alternatives. So when we look for the alternatives, because remember that we have said that witness statements are not serving the original purpose, we should keep in mind that whatever alternative we look for has to, the aim of that alternative should be as always to promote arbitral efficiency, reduce costs, and enable the tribunal as well as the parties to focus on the real issues in dispute. So there are three alternatives in my view. The first one is basically, you will be surprised, but it's let's keep witness statements, okay, and let's but not in the current form. We should apply some, let's say, measured changes, because the whole idea is to return to something closer to the original purpose. For that, we need to streamline content and as well as purpose. I suggest to follow a number of steps when we are setting about preparing a witness statement. So let's ask ourselves the question, is witness evidence the one that we intend or that we'll be including in the witness statement necessary? Is accuracy important? Is there a risk of contamination as well, in the sense that is there any other witness testifying on the same events or not? Also a very important element in my view in order to try and improve witness statements would be to always subject the witness to some degree of direct examination, okay, at the hearing. Why is that? Because in that way, I believe that you can keep the witness I mean, you can keep witnesses on their toes, and they will naturally refrain from delegating too much to, I mean, at the end of the day, the lawyer in the preparation of the witness statement. Because even though it's going to be that party's counsel asking the questions, obviously, those are going to be, as you, Philip, mentioned before, not leading questions, but open-ended questions. And obviously, the witness will be exposed to the possibility of maybe not being as consistent as they should with the witness statement that they've given. It's also useful using witness summaries and working from that, okay? Also, when it comes to the preparation itself of the witness statement, I think it was Baptiste that mentioned this before, and also Harris. it's important that the procedural orders contain limits and guidelines, in the sense that obviously a witness statement must contain all the matters that are relevant to the issues in dispute. They should avoid including speculation, conjecture, or commentary on another person's knowledge. Of course, they should not contain argument. They should keep the quotation of the documentary record to the bare minimum. Of course, as well, witnesses should only refer to documents which they received or were aware of before the dispute arose. And this is also an important point. I think, Philip, you mentioned it. The witness statement should identify what document have been used to refresh their memory. That is one alternative. Then there are those that argue that such measured changes wouldn't be enough, and that instead a memorial approach should be adopted versus the common law splitting approach. So what is a memorial approach? So this is a civil law tradition. It's basically all the documentary evidence, witness evidence, and legal submissions in one submission only. And that should assist parties in achieving efficiency in the presentation of their cases, and that should assist also the arbitral tribunal in reviewing the documentary record in preparation for the hearing. And then this is the alternative that I like the most, and which I have dubbed the unspecific solution. Why is that? Because I mean, arbitration practitioners should, in my view, challenge assumptions on how witness evidence through witness statements are deployed in arbitration. I mean, we should exploit to the fullest degree possible the flexibility that is supposed to be one of the strengths of arbitration. So let's try and be original in a way and find solutions, because we have the flexibility that allows us to do so. And I believe we're running out of time, so I will leave it at that, Philip, if that's okay.
Yes, Jose, yeah, you've got through the most important bits of strategy and witness statements, and I thank you for that. It's true, we are running out of time. I want to release everybody by midday Geneva time. That's in 3 minutes' time. Before I do so, I'll just mention that if you have any questions about this webinar or any of the webinars in our 2 series, please address them to me, Philip Landolt of Landolt & Koch in Geneva, and I'll see what I can do to answer them. Our next installment will be on recognition and enforcement of arbitration awards on Tuesday, the 28th of January, 10 a.m. Geneva time. It'll be led by former EB president, Jacopo Monacci-Naldini. And then the next installment of this particular series, Fundamental Skills in the Counsel Practice of Arbitration, will be on dealing with expert witnesses. And that's on Tuesday, the 4th of February, 2025. It'll be led by at 10 a.m. Geneva time. It'll be led by Jakob Jurgensen, Vice Chair of the EB branch of the Chartered Institute of Arbitrators. Please do join us. Again, if there are any issues, let me know by email. I'd like to thank our distinguished speakers for your contributions today. And I'd like to thank our attendees. It has been a very enriching and informative series. This webinar will be available, as I mentioned, on the EB site, on the European branch site, within the next 2 weeks. So if you want to, view that, you're most welcome to. Thank you all, and we'll see you in a week's time for our next installment.